Good afternoon, class. Today we will be starting with our lecture on the law on sales. Our source material for this portion of our course will be the law on sales, agency, and credit transactions by Hector S. De Leon and Hector M. De Leon Jr. Also, law on sales by Cesar L. Villanueva and Teresa V. Tiansay, and also notes in business law by Fidelito R. Soriano. So anyway, this is the first time we will be using a reviewer, but only for a portion of our lecture, specifically for yung Maceda law, because that is not discussed sa ibang books. So dun ko na lang kinuha, but again, I will discourage the use of reviewers, since ang reviewer is para lang sa review. Kung natapos nyo na yung RFBT 1 at magre-review na kayo para sa board exam, 1, 2, 3 syempre, magre-review na kayo sa board exam, doon lamang kayo gumamit ng reviewer. Kasi ang reviewer nga para sa review, but this is obviously your first time to study yung sales. So do not use reviewer. Masyadong kulang ang detalye, so lalo lang kayong mahihirapan. Kumbaga, ang alam nyo is ano lang, ampaw lang, hindi siya talagang in-depth. So anyway, let's begin with chapter 1 of the law on sales. It will talk about the nature and form of the contract. So remember, sale is defined in 1458 as a contract where one of the contracting parties obligates himself to transfer ownership and to deliver a determinate thing, and the other to pay a price therefore. So the person who will deliver the determinate thing is obviously your seller. The person who will pay the price certain is your buyer. So remember, class, technically, contract of sale transfers no real rights. It does not transfer ownership, because sale is not a mode of transferring ownership. It will only cause an obligation, certain obligations to arise. So on the part of the seller, the obligation to deliver object and transfer ownership will arise, and on the part of the buyer, the obligation to pay the price will arise. So remember, class, also that yung ownership is actually transferred by delivery or tradition. So remember again your Latin term. So delivery is a mode recognized by the law of transferring ownership. So obviously, a sale is a real obligation or obligation to give an object. Hindi pwedeng maging subject matter ng isang contract of sale ang mga service. So hindi ito personal obligation. So please take note of the characteristics of a contract of sale. It is consensual, meaning perfected by mere consent, as opposed to your real contracts and your formal contracts. So in a contract of sale, even if the price is not yet paid, the thing has not yet been delivered, pwedeng magkaroon ng perfection. So again, remember your stages in stages of the life of a contract: negotiation, perfection, and also termination. So mag-review kayo ng inyong oblicon kung nangangapa kayo, kasi hindi nyo maintindihan yung sales. What else? A contract of sale is also bilateral or reciprocal, meaning both parties are bound to fulfill obligations towards one another. So the seller must deliver object, transfer ownership, and buyer must pay the price. So remember, class, in case of failure to comply with yung obligations ng buyer and seller sa contract of sale, the remedy of rescission, or technically dapat resolution under 1191, is available to the parties. What else? A contract of sale is also onerous, meaning before you receive a thing, you have to give certain considerations as well. So if you are the buyer, before you receive the object, you have to pay the price. And also yung seller, for the seller to receive the price, he must deliver the object and also transfer ownership of the object. So onerous as opposed to your remuneratory contracts and your gratuitous contracts. We already studied them when we studied the contracts according to cost, kinds of contracts according to cost. So, valuable consideration must be given. So, may burden. What else? Commutative, meaning class, thing sold is considered equivalent of the price paid. So, technically, as a general rule, not technically, as a general rule, kung bumili ka ng object, yung ibabayad mo is equivalent of the value of the object. So, kung ang binayaran mo is 1,000 pesos, yung value ng object na binibili mo is supposed to be 1,000 pesos. But remember class, that is yung test of commutativity or commutativeness. In your book, it's commutativeness. The test of commutativeness is subjective. So, hindi naman kailangan na sentimo sa sentimo per sentimo is equal yung price nila. So, the price is not required to be exactly the value or equal to the value of the object. Hindi naman nire-require yon. Ang nire-require lang is that if the parties believe in all honesty that what they are receiving is good value for what they have transferred. So, kung ang buyer naniniwala siya na yung kanyang matatanggap na object is of the same value as dun sa perang kanyang ibibigay, the commutativeness of the contract is answered. So, nagko-comply pa rin tayo sa commutative principle. So, remember class here, subjective lang. Parties believe that they receive the appropriate or required or proper value para sa kanilang i-give up. So, anyway, this is the general rule, but obviously, there can be contracts of sale which are aleatory. So, aleatory is a classification of contract according to risk. So, remember, aleatory contracts wherein one party receives what may in time be greater or smaller than what he has given. So, ang pwede mong matanggap in time, pwedeng mas malaki or mas mababa ang value kaysa dun sa ibinigay mo. Like in case of sale of lotto ticket. So, anyway, bumili ka ng ticket ng lotto. So, kung nanalo ka, ito lang ang ibinayad mo. But what you have received is far more valuable than what you have given. So, aleatory yung contract na yon. So, it depends doon sa risk na tinitake mo. Now, paano kung natalo yung lotto ticket na binili mo, yung ticket na binili mo, natalo siya. So, remember, mas mababa yung value na receive mo kaysa dun sa binigay mo. So, pwede naman yan. Kasi, syempre, nagbayad ka ng 20 pesos para sa ticket ng lotto, tapos yung natanggap mo, walang kwentang pera lang, nakakapiraso. So, remember here, a contract of sale may also be aleatory. But as a general rule, it is commutative. What else? It is also nominate, meaning the civil code refers to it by a special name as opposed to your in-nominate contracts under 1307. What else? Your contract of sale is also principal. It is not dependent on another contract for validity. So, principal as opposed to preparatory and also accessory. So, accessory contracts are dependent on another contract for validity like your pledge, yung sangla sa pawn shop. So, pagka nagsangla ka sa pawn shop, actually, nangungutang ka din. So, there is a contract of loan. The contract of loan is a principal contract and dependent upon it is the contract of pledge which is accessory. Hindi ka naman magsasangla kung hindi ka nangutang. Remember, ano yun, pumunta ka sa pawn shop, bibigay mo yung alahas mo, tapos wala ka namang matatanggap in return. So, contract of pledge is an accessory contract. What else? Essential requisites of a contract of sale will refer to your essential elements as well. So, there must be consent or meeting of the minds. So, consent here is consent on the part of the seller to transfer ownership, deliver object on the part of the buyer to pay the price. So, obviously, the parties must be capacitated and they have must be legally capacitated, and they must have the capacity to give consent. But obviously there are sales against the will of the owner of the thing, like expropriation, which we will discuss later on. Yung execution sale to enforce a judgment of the court. Natalo ka sa kaso, sinisingil ka ng creditor. So nung natalo ka, debtor ka, hahabulin yung properties mo. Your properties will be sold at public auction. So, execution sale ang tawag nila doon. Obviously, ayaw mo yun. But this is a valid sale because it is ordered by the court. Foreclosure sale is also an example. Foreclosure sale of mortgage property or pledged property. Object, subject matter, determinate thing, which is the object of the contract. So, it may be real property or personal property, but not service. What else? Cost or consideration refers to price certain in money or equivalent, such as a check or a promissory note, or i-assume mo yung mortgage debt ng seller. Alam niyo yung pasalo? Yan, pwede ring consideration yan. So, there can be no sale without a price. But if you want to be technical, remember class, cost of sale in case of the seller is the promise of the buyer to pay the price. In case naman of the buyer, the cost for the buyer is the promise of the seller to deliver the object. So, technically, if you want to be technical. Take note also of natural and accidental elements. So, natural elements are deemed to exist in contracts even if they are not stipulated. So, nandyan yan kahit pag-usapan or hindi. Always there. So, warranties, eviction, hidden defects, which we will discuss later on. Now, to remove yung mga natural elements, there must be an express stipulation by the parties. Accidental elements naman, present or absent depending on the stipulations of the parties. So, kung pinag-usapan, nandyan, pero kung hindi pinag-usapan, wala. So, conditions, interest, penalty, time, place of payment are examples of accidental elements. Also remember in 1458 class that a sale may also be absolute or conditional. So remember, a contract of absolute sale is not subject to any condition whatsoever, and title will pass to the buyer upon delivery of the thing sold. So here, yung contract perfected siya. Yung perfection niya is not dependent upon any condition. Now, a contract of sale is conditional if it contemplates a contingency. So, contract is subject to condition. So, here, even if the object is delivered, it does not transfer ownership until the condition is fulfilled. So, delivery will not transfer ownership. So, yun ang tandaan natin, dalawang klase ng contract of sale. So, to determine whether or not the sale is absolute or conditional, you have to take note of this. If yung condition is imposed upon the seller's obligation to transfer ownership of the thing and deliver the thing, remember, this is a conditional sale. Now, if the condition is imposed upon the buyer's obligation to pay the price, the sale is still absolute. So, kahit na dineliver na yung object, tapos merong kahit na deliver na yung object, tapos merong condition, whether or not, and yung condition na yon will determine whether or not the contract of sale will push through, or whether or not the seller will deliver the object. Remember, that is a conditional sale. So, let us say, seller will have to prove ownership first before there is a sale. So, even if delivered na yung object, and also, let us say, price is paid. Pero if the seller does not prove ownership of the thing, remember class, kung halimbawa hindi niya na-deliver yung kotse, sabi na natin certificate of registration, yung CR, hindi niya na-deliver yan, remember, that is, there is no sale. Kasi nga hindi na nangyari yung condition. So, conditional siya. Yun ang conditional sale. Now, remember also na if ang contract is, let us say, hindi pa binigay ng buyer yung buong price, pero bibigay niya by installment. So, that is considered still an absolute sale. kahit na nakalagay ang wordings ng contract is ownership will transfer only upon payment of the purchase price, etc., etc., it is still considered an absolute sale because remember, it is already perfected. Meron ng contract except na binabayaran pa. Hindi lang nabayaran pa ng buo kaya hindi pa na-transfer yung ownership. But here, whether or not a contract of sale will arise is no longer a question kasi nga binabayaran na. So, absolute pa rin ang mga sales na ganyan. So, anyway, object of a contract of sale. So, remember, objects of a contract of sale may be, syempre, things and also rights. So, things, remember, must be determinate. Basic to. Must be licit, lawful, not contrary to lamog PP, not impossible. So, basic, pinag-aralan natin dati. Rights must be transmissible. So, if it is intransmissible or it is personal right, remember, it cannot be the object of sale. So, anyway, may mga examples naman dyan kung ano ang pwedeng mga rights na pwedeng i-transmit. Kung pwede mong i-transmit, pwede mong ibenta. If you cannot transmit it or if the right is personal, remember class that it is not possible to be an object sa contract of sale. So also services may be the object of a contract but it cannot be the object of a contract of sale. Kaya nga sinasabi ko real obligation ang sale. Ang pinag-usapan lang natin dito things, rights pala, o yan, and objects lang. Ganun lang, wala tayong service. Take note also of kinds of things. Remember, illicit per se, illicit per accidents. Illicit by per se is illicit by nature. What else? Illicit per accidents. It is valid sana, pero remember, because of a provision of law, nagiging illegal yung object na yan. So, if the object of the sale is illicit, remember, the contract is void. So, go back to chapter 9 of contracts kung hindi nyo na maalala yan. Right of the vendor to transfer ownership. The seller must be the owner of the thing sold. Or if the seller is not the owner, at least he must be authorized by the owner. So, vendor must be able to transfer ownership. So, kailangan siya ang may-ari or at least siya ay authorized by the owner. So, remember, class, that you cannot transmit or dispose of that which one does not have. Nemo dat cod non habet. So, yun ang tandaan natin sa 1459. Also, right to transfer ownership must exist at the time of delivery. So, pagka nagbenta ka ng object na hindi sa'yo, and yung object na yan hindi pa sa'yo at the time of perfection of the contract, okay lang yon as long as at the time of delivery or at the time ownership is to pass, kailangan ikaw ay meron ng right to transfer ownership. So, pwede kang magbenta ng hindi sa'yo. Sa totoo lang. Technically, if we will be technical. Pero at the time that you have to deliver the object transfer ownership, dapat meron kang right at the time. So, yun ang tandaan natin. So, what else? 1460. The subject matter of a contract of sale must be determinate. So, determinate ang object if it is obviously not generic, particular, designated, physically segregated from others of the same class. So, if it is not determinate, at least it must be, remember, sufficient or capable of being made determinate. If not determinate yet, it must be at least determinable. So, without the necessity of a new or further agreement of the parties. Halimbawa, lahat ng bebentang kita ng lahat ng laman ng basket na yan, may mga itlog yung basket. So at this time hindi mo alam kung ilang itlog ang binebenta mo. Easter Sunday kasi ngayon, no? Kaya yun ang naisip ko. So anyway, pagka binilang mo na yung laman na itlog ng basket, that is the time that it is already determinate. But remember here, class, it is capable, yung mga itlog na nasa basket, it is capable of being made determinate. How? Bilangin mo, period. So, yun ang tandaan natin. Basic, alam nyo na dapat yan. 1461 talks about emptio res perati, or in other books, emptio res perate, and also emptio spe. Kabulot itong mga to. Anyway, yung emptio res perati, it is the sale of things having potential existence. So, obviously, it will include a future thing. Kasi ang future thing, it is not existing at the time of the contract, perfection of the contract of sale, but it is possible to exist. Diba? Kanina, sabi natin, it is determinate. If it is not yet determinate, it is determinable. It can be made determinable. Yan. Without the need for another contract. Now, here in 1461, the object is existing. If not yet existing, it has the potential to exist. So, those kinds of objects can be the subject matter of a contract of sale. So, it is reasonably certain to come into existence as the natural increment or usual incident of something already in existence belonging to the seller. So, anak ng aso mo, wala pang anak yung aso mo ngayon, pero naturally, it is a natural incident na magkakaroon siya ng anak. So, if yung nanay na aso belongs to the seller, remember, naturally, it is capable na magkakaroon siya yung mga puppies niya is capable to exist as a natural increment or usual incident. So, title, remember here, in case of emptio res perati, will vest in the buyer the moment the thing comes into existence. So, sale of thing with potential existence. Yan ang emptio res perati. Sperate. Sige na nga. So, things sold must be specified, identified, and remember, class, vendor must own it at the time of that time ownership is to be transferred. Take note also of emptious pay or sale of hope or expectancy. So, class, remember, pwedeng ibenta ang pag-asa. Yan. Ito na naman. So, anyway, here in emptious pay, you are selling yung hope or expectancy, but there is a condition. The thing contemplated or expected will come into existence. So, possible na mangyari yung thing. So, here, it is a sale of hope itself. Now, what if, class, yung bagay na inaasahan does not come into existence? Remember, in case of emptious pay, the sale is still valid. Ang hindi valid dyan is the sale of false or vain hope. So anyway, mas maganda example na lang, lotto ticket. So remember, sa lotto, nagbebenta kayo ng paano ba yan? Yung pag namamag-asa kayo sa lotto na mananalo kayo ng prize, yung jackpot prize, kung magkano man yung millions na yan. So, remember, pagka bumili kayo ng lotto ticket, aside from being an aleatory contract, it is also a sale of hope or expectancy. So, remember, here, valid ang sale ng ticket ng lotto, provided, class, that the thing contemplated or yung or thing contemplated or expected will come into existence, meaning there is a possibility that it will happen. So, valid ang sale ng lotto ticket if it is possible na manalo kayo. So, paano ngayon kung hindi kayo nanalo? Okay lang yon, valid pa rin yung sale of hope or expectancy, because nung time na yon, na bago ma-draw yung ticket, possible na manalo kayo. Now, what if yung ticket na binigay sa inyo is peking ticket or ganun nga, peking ticket or na-draw na siya, ganyan. So, binenta pa rin sa inyo. So, here, class, this is a sale of false hope. Here, there is no possibility that the thing contemplated or expected will come into existence. Meaning, wala kayong pag-asang manalo. So, that is a void sale. Except, class, yung mga expired na ticket, ganyan, pwede pa rin naman siyang maging subject of sale as a collector's item. Pero, of course, that is a totally different situation. So, yun ang tandaan natin. So, in emptio res sperate, remember, sale of thing which is capable of existing in the future. Parang, ang example sa book nyo, wool ng sheep, ano pa ba, crops growing, grains of field, etc., etc. They are capable of existing in the future. Now, sale of hope or expectancy, remember, valid provided that it is possible to happen yung condition or yung inaasahan na bagay. So, take note of that. What else? Ayun na nga pala. Sale is valid even if the thing hoped or expected does not come into existence unless it is vain hope or expectancy, in which case sale is void. Sale of goods is covered under 1462, so you can sell existing goods. So, yung mga existing goods ay yung mga goods which are owned or possessed by the seller at the time of the sale. So, obviously, pwedeng ibenta yan. So, what else? Future goods as object of sale. Pwede ba ang future goods na ibenta? Yes. So, remember, goods which are to be manufactured, raised, or acquired by the seller after perfection of the contract, valid objects ng sale yan. So, valid only as an executory contract to be fulfilled by the acquisition and delivery of the goods specified. So, yun ang future goods. Anyway, example of future goods, sale of milk bottles to be manufactured with the name of the buyer, pressed sa glass, yung mga raised like harvest ng palay, mga examples lang sa book niyo yung kinukuha ko, or acquired, seller expects to acquire a parcel of land which he will sell to the buyer again. So, yun ang mga future goods, pwede naman silang ibenta. What else? Sale of undivided interest sa thing. So, remember, undivided interest, meaning, ikaw ang may-ari ng object, tapos, ang ibebenta mo lang is an undivided interest over the object, meaning portion. So, let us say, meron kang, ano bang example sa book ninyo? Yan, parcel of land. So, parcel of land, let us say, meron kang 2,000 square meters na parcel of land, tapos ang ibebenta mo lang is 1,000 square meters. So, remember, that is a sale of undivided interest in an object. So, seller may obviously sell the entire 2,000 square meter parcel of land, but also seller can sell only a specific portion or an undivided interest. So, such interest may be designated as an aliquot part of the whole. What else? Legal effect nito is buyer will become a co-owner. So, dalawa na kayong may-ari. Let us say, ang binenta mo lang sa buyer is 500 square meters. 500 square meters sa buyer, 1,500 square meters sa'yo. So, co-owners kayo. Pwede yon. Now, a co-owner may also sell his undivided interest in a thing. So, let us say, yung buyer mo na nakabili ng 500 square meters dun sa lupa mong originally 2,000 square meters can dispose of his share. Kailangan pa ba niya ng consent mo na may-ari ng 1,500 square meters? Hindi na. It can be your buyer who bought yung 500 square meter portion can dispose of his share even without your consent. So, anyway, here, with respect to the 500 square meters na binili ng buyer, he is the absolute owner of that. So, he can dispose it without your consent, but remember, yung kanyang alienation is limited only dun sa portion na nabili niya. So, his alienation is limited only to his 500 square meter portion. So, yun ang sale by co-owner. Sale of undivided share of a specific mass. So, please take note of the definition of fungible goods. So, fungible goods are replaceable by equal quality and quantity of goods, either by the nature of things or by common agreement. Some books, they call them interchangeable goods. Grain, oil, yan. It is replaceable by another of yung same goods without loss or of value. So, remember, these are the rules. Number 1, as to effect, owner of a mass of goods may sell only undivided share thereof, provided that the mass is specific or capable of being made determinate. So, yung owner ng mass may sell yung entire mass. So, let us say, lahat ng palay na nasa loob ng isang warehouse, pwede niyang ibenta yan. But also, the seller may sell only an undivided share of the mass. So, here, the mass is specific. Anong mass yan? Itong nasa warehouse ni A dito sa ganitong address, specific warehouse, etc. So, the mass is specific. Now, remember the qualifications. Number 1, buyer will become co-owner with the seller of the whole mass in proportion to dun sa definite share na binili niya, in proportion to the whole mass. So, let us say, yung sa isang punong-punong warehouse ng bigas, binenta lang is yung kalahati. So, half of the mass. So, yung buyer is the co-owner of the seller of the whole mass, but remember, in proportion only dun sa portion na ibenta sa kanya. So, definite share bears to the mass. So, 1/2, ito yung mass. So, 1/2 of the mass is yun ang magbibilong sa buyer. So, also, remember, the share of each owner will be determined only by measuring the entire mass. So, kailangan para malaman yung 1/2 share, kailangan i-measure yung buong mass. So, that would apply kung hindi alam ng parties, yung, especially the seller, kung gaano karaming bigas yung kanyang nandun sa warehouse niya. So, anyway, measure mo para malaman mo kung gaano karami. So, 1/2 will go to the buyer, as in our example. Now, what if, let us say, the seller owns 500 kilos of rice, tapos nakastore siya sa isang warehouse. So, pwede niyang ibenta ang portion noon, let us say 100 kilos of rice. So, ang alam niya, meron siyang 500, tapos nagbenta siya ng 100 kilos ng bigas. So, anyway, noong nagkataon, nung i-deliver na sa buyer, so, syempre, i-measure nila yung 100 kilos ng bigas. But it turns out, class, na yung bigas is kulang sa 100. So, remember, class, yung buyer will become the owner of the entire mass. So, yun ang if kulang, the buyer becomes the owner of the whole mass, and furthermore, seller shall also supply whatever is lacking from the goods of the same kind and quality. So, any stipulation to the contrary, subject to any stipulation to the contrary. So, yun ang tanda natin in case of goods which are undivided. Yung undivided share pala sa specific mass. So, risk of loss will be all owners will bear the risk of loss. So, lahat ng co-owners will bear the risk of loss in proportion to their various holdings doon sa mass. What else? Subject matter here. subject matter is an incorporeal right. So, yung portion lang na, syempre dahil undivided siya, right mo lang yan sa portion na binili mo. That's why it is incorporeal right. So, ownership here passes by intention. So, remember, there can also be a sale of things subject to a resolutory condition. So, this is provided for in 1465. So, here, if the resolutory condition attached to the object of the contract should happen, the vendor cannot transfer the ownership of what he has sold, since there is no object. So, remember, yung resolutory conditions nyo, go back to obligations kung hindi nyo natatandaan. But for now, a resolutory condition will extinguish the obligation as a rule. So anyway, if the resolutory condition is attached to the object, remember, the vendor cannot anymore transfer ownership of what he has sold. So anyway, the example here is usually in case of a foreclosure. The foreclosure referred to here is extrajudicial foreclosure. So meaning foreclosure without necessarily filing a case in court. So anyway, debtor, meron siyang utang kay creditor to secure payment of the obligation. Si debtor, sinangla niya yung kanyang lupa kay creditor. So anyway, hindi na makabayad si debtor, itong si creditor, gusto na lang niyang i-foreclose yung or irimata yung lupa ni debtor. So pagka nagkaroon ng extrajudicial foreclosure, remember, ibebenta yung property sa public auction. So let us say na ibenta sa public auction, may nagbid. So remember, class, here that according to Act 3135, mayroong 1 year para i-redeem ng mortgagor yung property that is sold at public auction. So, or extrajudicial foreclosure sale, meron siyang 1 year to redeem. Yung 1 year period is counted from the date of sale, but more specifically, this will refer to the date of registration of the certificate of sale with the registry of deeds. So, pagka kasi nagkaroon ng foreclosure sale, may bidder, nanalo yung bidder na to, yung usually it is the sheriff or it is the clerk of court who will issue a certificate of sale, tapos irerehistro yan dun sa titulo ng lupa. Now, if within the 1 year period, yung right of redemption or yung right to buy back the property is actually a resolutory condition. Now, if the mortgagor or yung debtor na may utang is able to buy back the property within the period provided, which is 1 year, remember that the vendor, here the vendor is the court, ay yung nagbenta, sheriff, ganyan. The vendor here cannot transfer ownership of what he sold since there is no object anymore. So obviously, the bidder, highest bidder, will not become the owner. So yun ang tandaan natin sa 1465. So please take note also of agency to sell. So contract of agency is defined in your book. A person binds himself to render some service or to do something in representation or on behalf of another person, obviously with the consent of the person who is represented. Please take note also of the differences between sales and agency, agency to sell. So tandaan nyo yung mga pagkakaiba niyan. So 1466 talks about the differences. So in a sale, the buyer will receive the goods as owner. Agency to sell, agent, the buyer, agent will receive the goods as goods of the principal. The principal will retain ownership over them. And syempre, dahil siya ang owner, he has a right to fix the price of the sale, terms of the sale, and remember later on kung nabenta, receive yung proceeds ng sale. Pero syempre, may commission yung ahente. So, sa sale, yung nakabili na nakatanggap ng goods, sila na yung magiging may-ari. In agency to sell, yung tatanggap ng goods dito is yung ahente. And yung ahente should sell it to another person. Now, remember here, the goods belonging still to the principal. The principal has the right to dictate yung price, term, and remember later on, receive also the proceeds of the sale. What else? Buyer has to pay the price in a sale, common sense. In agency to sell, agent simply has to remit yung proceeds of the sale. He may make to the principal. So, account for the proceeds of the sale, remit it to the principal later on. What else? In a sale, yung principal na word class, it refers to the person who is represented by the agent in case hindi nyo alam. Diyos. Ay, nako, dapat alam nyo na yan. Anyway, in a sale, also, buyer cannot return the object sold, subject to exceptions, but that is a general rule. In agency to sell, if the agent is not able to sell the goods, he can return yung object. So, what else? Kasi hindi naman siyang may-ari, di ba? Remember, it is still the principal who is the owner. So, kailangan ibalik yan. Kung hindi binalik, estafa yan. Tandaan nyo. So, anyway, in a sale, remember, seller will warrant the thing. So, lahat ng warranties bibigay ng seller. Agency to sell, the agent who is the seller here will make no warranties. He will not assume personal liability provided that he acts within the authority given to him and also in representation of a seller. What else? Sale, buyer can deal with the thing sold as he pleases. Siyempre, siya nang may-ari. Kung gusto niyang sirain yan, gamitin yan, etc., okay lang, siya ang may-ari eh. In agency to sell, remember, the agent who is dealing with the thing is bound according to the instructions of the principal. So, kung anong sinabi ng principal na gagawin, store mo yan dito, ganito ang gawin mo dyan, kailangan sundin ng agent yan. Because, remember, the agent is not the owner yet. So, the agent is not the owner. So, kailangan niyang sundin kung ano man, whatever the instructions of the principal. So, yun ang tandaan natin sa agency. So, kailangan i-remit ng agent yung price paid ng mga third persons who are buyers from him, less yung kanyang commission. Yan. So, yun ang pinagkaiba. What else? 1467 talks about a contract for a piece of work and also yung contract of a sale. So, contract for a piece of work is defined in 1713. Contractor will bind himself to execute a piece of work for the employer. So, in consideration of a certain price or compensation. So, contractor here may employ labor or skill and also he can furnish yung material. So, yun ang 1713. Now, why is it important to determine whether a contract is a contract of sale or a contract is for a piece of work? Because remember, there are different rules governing yung dalawang yan, which I will discuss later on. But before that, schools of thought, Massachusetts rule, sabi niya, if it is specifically done at the order of another, this is a contract for a piece of work. So, kung in order at ginawa mo dahil sa order, this is piece of work. Now, remember, yung New York rule also, if the thing is already existing, it is a sale. If it is not existing yet, it is a contract for a piece of work. Yung pangatlong rule naman is yung English rule. So, it depends on the value of the material. If the material is more valuable, it is a sale. If skill is more valuable, it is a contract for a piece of work. Now, remember here, the Philippines, we adhere to the Massachusetts rule. Now, kung in order, dahil sa order na yan, ginawa mo, it is a contract for a piece of work. Now, kung regularly ginagawa yan, kahit na nung time na may bumili, out of stock siya, pero kung regularly ginagawa yan, it is still considered a contract of sale. So, to elaborate more on the rule, if it is ordered, yung Massachusetts rule, which is the one we follow in the Philippines. So, if it is ordered or manufactured in the ordinary course of the business, sale. Kung talagang ginagawa niyo itong product na to, sale yan. So, kung hindi nyo ginagawa yung product at ginawa nyo lang dahil may nag-order nitong ganitong klaseng product, remember, if it is not for the general market, it is a contract for a piece of work. So, now, remember, again, kung minamanufacture regularly in the ordinary course of business, even if it is out of stock right now at kailangan pang gumawa, sale pa rin yan. Because remember, ordinary course of business. So, anyway, example na lang, let us say, magpapagawa ka ng sapatos, yung paa mo is isang paa, may 10 daliri. So, obviously, kailangan pasadya yung iyong sapatos dyan. So, remember, class, that if you will order this kind of shoes from a shoe manufacturer, it is a contract for a piece of work. Because obviously, hindi naman magmamanufacture on a regular basis in the ordinary course of business. Hindi magmamanufacture ang shoe seller or manufacturer ng sapatos na pang 10 daliri ang bawat isang paa. So, remember, now if your shoe size is, let us say, size 14, tapos walang size 14, gagawa pa lang yung manufacturer. But because, remember here, the manufacturer manufactures shoes of all sizes up to size 14. So, hanggang size 14, covered pa yan. So, remember here, this is, again, a contract of sale. Because, even if out of stock ngayon, it is manufactured in the ordinary course of business. Now, why is it important to determine whether or not a contract is for a piece of work or a contract of sale? So, remember, class, in case of risk of loss. So, pagka risk of loss, before delivery, in case of a contract for a piece of work, risk of loss before delivery is borne by the worker or contractor. So, kung sino yung nagpagawa, siya ang magbe-bear ng risk. Sino yung gumawa, yan. Yung gumawa, siya ang magbe-bear ng risk of loss until and unless na-deliver na niya dun sa nagpagawa. Now, in a contract of sale, the risk of loss is borne by the buyer. So, after perfection but before delivery, the risk of loss is borne by the buyer. Also, class, contracts for piece of work are not covered by the statute of frauds. Kung hindi nyo natatandaan yung statute of frauds, balik kayo sa chapter 8 ng contracts. Ano ba yan? But remember, class, here, contracts of sale are covered by the statute of frauds, as we will discuss later on. Ang dami ng discussion sa chapter 1. We will try to discuss them. So, I'm trying to minimize lahat ng itong video na to as short as I can. But remember, this is 63 slides class. Ang daming topic talaga. So, anyway, also important to determine, mas mababa kasi ang tax ng contractor. Kaya, kaysa sa sales sa kaysa sa tax para sa sale. Kaya it's very important to determine whether or not your contract is for a piece of work or contract of sale. Ang daming cases sa Supreme Court niyan, wherein yung parties, they claim that they are contractors, tapos yung mga contracts they entered into is for a piece of work para lang maka-avail sila ng mas mababang tax. Pero yun, later on, the Supreme Court decides that they are contracts of sale. So anyway, please take note of that. Barter, we already studied barter in passing. So ito yung one of the parties binds himself to give one thing in consideration of the other's promise to give another thing. So sinabi ko na sa inyo to, swap. So ito yung do ut des, dating innominate contract but technically no longer an innominate contract, but it is called now as barter, which we will discuss later on. Also, there is a separate chapter for barter. Around the two provisions, I'm not sure. So anyway, the rules in case of barter. So intent will prevail. So manifest intention, ba yan? but the manifest intention of the parties is paramount in determining whether it is one of a barter or a sale. So, kung anong intention ng parties, yun muna siya. Now, it is taken into consideration in whether, in ascertaining whether or not the sale is a barter or sale. Whether that the exchange pala is barter or sale. So anyway, but the parties' contemporaneous and subsequent acts may be taken also into consideration. Now, if intention does not appear clearly, it is considered as barter if the value of the thing given as part of the consideration exceeds money or equivalent. Otherwise, it is, remember, sale. So, kung yung amount ng thing is mas malaki doon sa value ng money, it is barter. Now, if mas malaki yung pera na binigay kapalit ng and may bagay, remember, it is considered as barter. So, let us say parcel of land worth 1 million. Tapos, ang sinaswap sa kanya is pera and also a car. So, remember, whether or not this is a barter or a sale will depend first on the intention of the parties. So, A has a parcel of land worth 1 million, tapos itong si B meron siyang kotse and pera approximately worth also 1 million pesos. So, whatever it is, depends on the intention of the parties. Tignan muna natin. Now, if the intention does not clearly appear, remember, if let us say yung kotse is 600,000 ang value niya, tapos yung pera is 400,000, this is considered as a barter if the intention of the parties does not clearly appear. Now, if the money is, let us say, 600,000 pesos and yung object, car, is 400,000 pesos, na isa-swap mo dun sa parcel of land, remember, this is considered a sale. Now, question, ma'am/sir, paano, ma'am/sir, kung equal 500,000 yung object and also 500,000 yung pera na isa-swap doon sa parcel of land. Remember, if 50-50, it is, remember, a sale, considered a sale under the law. Take note also of the rules on money exchange. So, kung nagpapapalit kayo ng dollars, yan, foreign. If local currency, yung peso nyo is exchanged for foreign currency, so peso, bumili kayo ng dollar, yun na, nakuha nyo na yung term, nakuha nyo na yung clue. So, it is actually a sale. So, if you exchange your peso to dollars, it is a sale. Now, kung papapalit nyo yung 1,000 yung papel sa baryang halagang 1,000 rin of the same currency, peso to peso, it is considered as barter. So, foreign currency exchange in the Philippines of another foreign currency is also considered as barter. So, kung yung $100 mo ipapalit mo with with another foreign currency, let us say euro, etc., it is also considered as barter. So, yun ang rules natin when it comes to barter. So, anyway, 1469, cost. Nasa cost na tayo. Kanina, consent, tapos ngayon, kanina object, tapos ngayon ay cost na. So, remember, cost talks about price certain. So, money, currency, which is currency and its equivalent means promissory notes, checks, and other mercantile documents generally accepted as representing money. So, the requisites for a valid price, it must be real, it must be certain, or at least ascertainable by simple mathematical calculations. In money or its equivalent, the manner of payment must be agreed upon by the parties. So, rules regarding price, no sale if the price is not certain or ascertainable. Sinabi na natin yan, there can be no sale without a price. So, kailangan alam natin kung magkano ang benta. Price in a contract of sale should be settled for there can be no sale without a price. If not certain, it must be at least ascertainable. So, yun ang tandaan natin dyan sa number 1. What else? Number 2, other rules. Cases when price is considered certain if the parties have fixed or agreed upon a definite amount, common sense. Certain with reference to another thing certain. For example, price is fixed at 10% below price in the sales invoice. Yan. So, yun ay yung price sa sales invoice is price certain. Now, 10% below it is also a price certain because it is fixed with reference to a price that is certain. So, example also, yung tuition, the price is the same as the tuition charge. Kung sabihin tuition at saka fee, pareho lang yun. Redundant na yan. So anyway, tuition sa UP, let us say, para sa isang SEM, hindi rin pangit na example yun. Because remember, sa UP, it is dependent on the income that is, yun ang tuition nila doon. So, mas maganda siguro, Lasal yan. So, sa isang SEM sa Lasal, that is the price. So, it is certain with reference to another thing which is certain. So, what else? Determination of price is left to the judgment of a specified person or persons. Pwede ba yan? Yes, remember, it is applicable only when no specific amount has been stipulated by the parties. So, let us say, Board of Assessors will fix the price. Okay lang yan sa pagdating sa determination if the price is certain. So, what else? Price is also certain if fixed by the courts. So, usually, yung courts will fix the price only if the third person, as in number 3, fixes the price in bad faith or by a mistake. Fixed by reference to a definite day, particular exchange, or market. Anyway, we will discuss this later on. Parang equivalent yan sa price ng stock ng ganitong araw sa ganitong stock market, etc. So, yun ang number 5, which we will discuss later on. So, effect when the price is fixed by a third person who is designated by the parties. General rule, binding upon the buyer and seller. What are the exceptions? If the third person acts in bad faith or by mistake. So, mere error in judgment. Kung talagang nagkamali lang talaga. Remember, this is not a basis for questioning or impugning the fixed price fixed. Pero kailangan talaga ng bad faith or mistake before you can question the price fixed by a third person. Third person disregards specific instruction or procedure in making a determination of the price or the data given by the parties, ignore niya, and therefore an arbitrary price is fixed by the third person. So, what about if the price is not fixed by a third person? Remember, class, the contract is ineffective. No price, no contract of sale. Unless, of course, later on, the parties will agree among themselves kung ano yung price. What else? Third person is prevented from fixing the price by the fault of the seller or the buyer. So, party at fault may obtain redress. Party not at fault may obtain redress against the party at fault. Rescission, fulfillment, damages in either case. So, in this case, remember, innocent party, if he chooses fulfillment, court will fix the price plus damages. Yeah. What else? Gross inadequacy of price in voluntary sales. So, general rule, even if there is gross inadequacy in 1470, the contract is valid. It does not affect yung contract of sale, especially if the price is fixed in good faith and without fraud. So, the exception, kasi basta meron kang binayad, valuable consideration is given, however small or nominal, as long as given in good faith, there is no fraud, it is sufficient. Remember, sabi ko nga sa inyo, as long as the parties believe that they are receiving a good price for in exchange for whatever they have to transfer, okay yan. So, what else? Except low price indicates a defect in the consent. So, remember your vices of consent. Fraud, mistake, undue influence. So, pwedeng i-annul yung contract because of these vices of consent. What else? Price is so low to be shocking to the conscience. Sobrang nakakabigla siya. So, shocking yan. Ang sabi ng Supreme Court dyan, where a man in his senses and not under a delusion would not accept it. Yan. So, here, class, the sale may be set aside also. In case also number 3, price is simulated, such as when the parties intended a donation or some other contract, which we will discuss later. Na-discuss na natin to actually, relative simulation ito eh. So, number 4, parties do not intend to be bound at all. The contract is obviously void and inexistent. So, this is absolute simulation, which we have discussed already in contracts. So, in involuntary sales, the effect of gross inadequacy of the price is number 1, not again sufficient ground for cancellation of the sale. In the event that it can be shown that if there is a resale, a better price can be obtained. So, exceptions, again, shocking to the conscience ang price. Sobrang baba naman, nakakashock. What else? In the event of a resale, a better price can be obtained. So, that is an exception. In cases also of your pacto de retro sale, so yung pacto de retro sale is sale with a right to repurchase. So, ibebenta mo, but the buyer will give you a right to repurchase yung property which you have sold. So, seller ka, binenta mo sa buyer mo, buyer will give you a right to repurchase your property. So, usually mababa yan eh. Kasi nga, you want to give the seller the best possible opportunity or chance to repurchase yung property. So, kung mababa ang pagkakabenta sa buyer, tapos may right to repurchase, syempre mas madaling i-repurchase yan kasi mababa lang ang pagkakabenta sa buyer. So, the seller can easily repurchase. And sa repurchase, remember, your seller will become your buyer and your buyer will become your seller now. Redemption will be easier. Yan. Also, your right of redemption may be sold to recover yung insufficiency of the price anyway. So, what else? Price is simulated in 1471. So, remember the definition of simulation in 1345, which we have already studied. Kung hindi nyo pa rin bumalik kayo, nag-bid terms na tayo, hindi nyo pa rin alam. Anyway, effect where the price is simulated. Remember, in case of relative simulation, here, the contract is not simulated, but the price is simulated or false. So, real vendor here intended to transfer the thing gratuitously, such as in a donation. So, sale is void, dahil wala naman talagang binayad, but the contract is valid as a donation. What else? Bakit ganito naman yung mga slides ko? Absolute simulation, if the contract is not shown to be a donation or other contract, because the parties do not intend to be bound at all, the ownership of the thing is not transferred. So, parties, walang consent ito sa absolute simulation. Kaya, absolutely simulated contracts are void contracts for lack of an essential element, which is consent, na sinabi ko na noon sa obligations and contracts pa lamang. So, anyway, void contract. What else? Price of where the price is price of securities, grains, liquid, and things considered certain. So, price fix is that which the thing would have on a definite day or in a particular exchange or market. So, yung example ko nga kanina, ito ang presyo sa ganitong palengke ng ganito, yung araw na to, yan ang ating, kung magkano bentahan sa palengking ganito, etc. Sa Tarlac City Public Market, ito ang price niya. So, yun ang bentahan natin. So, that is definite price. What else? When an amount is fixed above or below the price on such day or in such exchange or market, etc. Otherwise, the sale is without force and effect because the price cannot be determined. So, provided yung basis ng price is certain. So, yung price ng bigas sa Tarlac City Public Market ng ganitong araw, ganitong klaseng bigas, minus 10 pesos. Yan. Price is fixed above or below price on such day, etc. etc. Rules regarding fixing of price in 1473, determination of the price cannot be left to the discretion of one of the contracting parties based on the principle of mutuality of contracts. Kung hindi nyo na naman natatandaan yung mutuality, balik na naman kayo sa Contracts, Chapter 1. Ano ba yan? So, anyway, what else? To be just, the price must be determined impartially by both parties or left to the judgment of a specified person or persons. So, pwede namang isa lang mag-fix ng price, but if it is accepted by the other, contract is perfected. Kasi may meeting of minds pa rin dahil nga inaccept ng other party yung price fixed by one of the parties. Yan. Failure to determine the price in 1474, what is the effect? The general rule, if price cannot be determined, the contract is inefficacious. Ayan, nilagay ko na yung ibig sabihin. Inability to produce the effect wanted. So, there is no obligation of the seller to deliver the thing, and the buyer does not need to pay. Diba? No price, no sale. Exceptions, if there is partial performance. So, seller has already delivered the object or a part of the object, and nagamit na ito ng buyer, appropriated by the buyer. So, the buyer must pay a reasonable price, therefore, which is generally market price at the time and place fixed in the contract or by law for the delivery of goods. So, perfection of a contract of a sale. Again, remember your stages of a contract: negotiation, perfection, termination. So, the contract of sale is consensual, perfected the moment consent is given, meeting of minds na naman upon object and price. There are reciprocal obligations already pagka nagkaroon na ng perfection, even if wala pang nabayad, wala pang na-deliver. But remember, ownership is not yet transferred until and unless there is a delivery. So, in case there is no compliance on the part of one of the contracting parties, injured party may sue for fulfillment or rescission with damages in either case, as in accordance with 1191, which covers reciprocal obligations. So, requirements for perfection. Bakit balik-baliktad yung aking slide? Medyo naiirita na ako. Parties are face-to-face. Offer is accepted without conditions, without qualifications. So, perfected. Yan. Meron kang definite offer. Your acceptance is without condition, meaning absolute. So, perfected contract of sale. Ma'am/sir, paano kung by phone? Pagka by phone, remember, it is as if the parties are face-to-face. Alam ko, piloso po kayo eh. Ganyan tayo eh. Number 2, if in case of contract through correspondence, through telegram, sulat-sulat, there is perfection when the offeror receives or has knowledge of the acceptance of the offeree. So, if the buyer accepted yung offer ng seller, and the buyer communicates his acceptance to the seller is receives yung acceptance, alam na niya na ina-accept yung kanyang offer, contract is perfected. So, it goes to show also that in case the seller does not know yet of the acceptance of the buyer, the seller, there is no perfected contract of sale yet. Pwede pang i-withdraw nga yung object. What else? if the sale is subject to a suspensive condition, perfection is had from the moment the condition is fulfilled. So, remember here, class, again, ano yung suspensive condition? Tignan nyo na naman sa book ninyo. Nasa obligations and contracts yan. Kayo nang bahala dyan. Formalities under 1403 or yung statute of frauds. So, under the statute of frauds, sale of real property, regardless of amount, kahit 1 square meter lang yan, basta ang binibenta mo lupa, it must be in writing to be enforceable. So, under the statute of frauds. Number 2, in case naman of personal property, if 500 or more, must be in writing. Baka mamaya yung teacher nyo na naman, meron kasing isang teacher sa tax, sabi niya 5,000 daw yan. Mali yun. Yung 5,000 refers to a donation of real property, yung value na 5,000. So, if the donation is more than 5,000 pesos, remember, the donation and acceptance must be made in writing. So, it is required for validity. Otherwise, yung donation of personal property is void. But here we are talking about sale. Yung teacher kasi na yun, sinabi niya, hindi raw updated yung mga lawyers kasi 5,000 na raw according to book. But obviously, may value na may figure na 5,000, but it refers to donation. So, for sale, 500 or more. But remember, in donation, above 5,000. So, here, 500 or more must be in writing to be enforceable. What else? Also in writing should be sales, which are to be performed only after more than 1 year from the time the agreement was entered into, regardless as to whether property is real or personal and regardless of the price involved. So, kung ang buyer and seller, the sale is in the future, magbebentahan pa lang sila only after more than 1 year. Remember, the agreement to enter into a contract of sale in the future must be in writing. Yan. Yung performance yan, agreement, yung performance ng sale must be is only after more than 1 year pala. It should be in writing. So, if the delivery and payment must be made after more than 1 year, remember, it should be in writing. So, balikan nyo yung chapter 8, tamaan, enforceable contracts. If not, remember class, the contract is unenforceable. Number 4, law requires a document or other special form. The contracting parties may compel each other to observe that form in accordance with 1357. So, sale of real property in a private instrument is not registrable. So, buyer, nagbenta siya ng lupa, bumili siya ng lupa from seller, it is in a private instrument. Remember, that is not registrable. But in 1357, the parties, either of the parties may compel the other one to execute the necessary deed of sale, or para maging at panataryo siya, para public instrument siya, so that it can be registered. Yan. So, effect of failure to pay yung price. So, failure to pay the price stipulated does not nullify yung contract. Yan. So, vendor's remedy in such a case is to demand specific performance or rescission with damages in either case in accordance with 1191 again. If there is no price stipulated, so remember, contract of sale is null and void. So, lalong-lalo na kung kahit na nakalagay na that the price is paid but in truth and in fact, wala naman talagang nabayad. So, no price, no sale. So, what else? Wow, auction sales. So, auction sales, we already discussed in passing, yung tungkol sa bidding. Diniscuss na rin natin yan. So, the rules governing auction sales in 1476. So, sales of separate lots by auction or separate sale. So, you have to define first, ano ba yung lot? A lot is, pwede siyang isang object lang. Pwede siyang maraming object. Basta, ang point dyan is, ibinebenta sila na magkakasama. So, let us say, meron akong isang object, binenta ko sa auction, that is one lot. Meron akong tatlong object na pinagsama-sama ko, tapos binenta ko ng minsan sa auction, that is one lot again. So anyway, sale of separate lot or separate sales. So, binenta ko yung aking may kutsilyo ako, binenta ko, isang lot yon. Tapos meron akong combination ng kutsara, tinidor at saka bread knife, isang lot din yan. Binenta ko rin ng as one lot. So, remember, yung sale ng aking kutsilyo, sale ng aking set na bread knife, kutsara, tinidor, separate lot, they are separate sales. So, there is a separate contract in regard to each lot. So here, sale naman is perfected, remember, by the fall of the hammer. So, sale is perfected when the auctioneer announces its perfection by the fall of the hammer or in any other customary manner. So, if you are watching yung, ano ba yun, yung nasa Storage Wars sa History Channel, something like that. So, dun wala naman silang hammer, but they, yung sale nila is perfected by some customary manner. So, hanggat hindi pa na perfect yung sale, bidder may retract the bid. Auctioneer or yung nagpapa-auction ng object may withdraw the goods from the sale, except if the auction is announced to be without reserve. Pagka without reserve, wala nga reservation eh. So, whatever the bid is, kailangang ibenta ng auctioneer yan. Hindi niya pwedeng i-withdraw yung kanyang goods. Right of seller. Pwede bang mag-bid ang seller sa auction? Yes. Usually, ginagawa nila yan para saan? Para pataasin yung price ng lot na binebenta nila. So, here, remember, the seller may bid in an auction sale provided that he complies with the requisites of law. So, what are the requisites? The right to bid was reserved, meaning nilagay niya na magbibid ako. Yan. So, ni-reserve niya yung right niya to bid. And also, notice is given that the sale by auction is subject to the right of the seller to bid. So, notify also the bidders that the seller is allowed to bid. Now, what happens if the bidders are not aware that the seller has a right to bid? The sale can be treated by the bidders as, remember, fraudulent. So, yung mga bidders could be, or yung buyers, yung nanalo sa bid, the buyer could be relieved from his bid. So, he is allowed to not to pay yung kanyang bid and to yung withdraw his offer. So, yun ang tandaan nyo, this is on the basis of fraud. So, also, seller can employ other persons to bid for him as long as he has notified the public. So, again, if there is no notice, the purchaser could be relieved from his bid. So, yung third persons who bid on behalf of the seller or auction of the seller pala is called your buy bidders, BY-BIDDERS, or puffers, PUFFERS. So, remember class na it can happen that the auctioneer, yung nagpapa-auction, is not the owner of the goods. So, or not the owner of the goods. Now, if yung auctioneer, siya ang kumuha ng mga buy bidders or puffers without notifying the public, yung good faith or bad faith ng seller, whether or not the seller knows na merong buy bidders at saka puffers. Remember, immaterial yan, yung knowledge ng seller. The sale will still be considered as fraudulent, even if hindi yung seller ang nag-hire ng puffers, pero yung auctioneer. So, transfer of ownership in 1477, ownership of the thing is transferred by delivery. So, not perfection delivery, which may be actual delivery or constructive delivery. So, remember, payment of the price, delivery of the object is not essential to perfection of the contract. Yung ownership is transferred only upon delivery of the thing. Yan. What else? Non-payment creates only a right to demand payment or to rescind the contract, plus damages in either case in accordance with 1191. In case naman of bouncing checks ang pinabayad mo, criminal prosecution. So only after delivery, purchaser acquires real right or ownership over the thing. Exception in 1478, parties may stipulate that despite delivery, ownership shall remain with the seller until price is fully paid. So usually this is applicable in sale by installments. Yan. Usually dun ginagawa yan. So this stipulation is known as pactum reservati domini or contractual reservation of a title. So pactum reservati domini, again, remember your Latin terms. Option contract is not anything new. We already studied this. So option, contract granting a person privilege to buy or not to buy certain objects at any time within the agreed price and agreed period. So option contract is a separate contract from the contract of sale, which the parties may later on enter into. So being a separate contract, the option must have its own cost or consideration. So kinds of remember, in pala to add to that, in 1324, remember the rule, if the offer is not supported by a consideration, it may be withdrawn before acceptance, even if hindi pa lapse yung period na binigay nung offerer dun sa offeree. So anyway, the kinds of promises treated in 1479, the accepted unilateral promise to sell. So yung one party may promise na magbabay, promise na magbebenta, promise to sell, and the buyer may accept this promise to sell of the seller without necessarily promising to buy. Sabi ng seller, benta ko na sa itong kotse ko. Tapos sabi ng buyer, okay, pero hindi na nga ako ang buyer na bibili niya. That is an accepted. Yun ay isang accepted unilateral promise to sell. Now, also, accepted unilateral promise to buy. So, here, sabi ng buyer, bibilin ko yan, sabi niya. Bibilin ko yan, object ng seller. Tapos sabi ng seller, okay, but the seller here does not promise to sell. Basta tinanggap lang niya yung unilateral promise to buy. So, remember here, the effect of unilateral promise. So, only one makes the promise is accepted by the other. So remember, class, here that it does not bind the promisor even if accepted, and it may be withdrawn at any time. Yun nga sinabi kong general rule in 1324. Unless, class, again, the consideration is supported by, if the promise pala is supported by a consideration distinct and separate from the price, that its acceptance will give rise to a perfected contract. So, remember here, class, also sa option contracts, yung mutual promise, yung kanina unilateral promise, ito mutual. So, Dalawa, mutual promise to buy and sell. So, contracting parties will have personal right in that each has the right to demand from the other fulfillment of the obligation. So, promise to buy and to sell. This is as good as a perfected sale. So, wala pa namang title which is transferred, but kasi nga wala pa namang delivery, but the parties will be given a right to demand fulfillment or damages. So, yun ang tandaan natin sa bilateral promise to buy and to sell. So, mutual promise. So, effect. So, practically the same effect as a perfected contract of sale because it is reciprocally demandable. Remember also the term policitation in English. So, remember, unilateral promise to buy or sell which is not accepted. Benta ko sa iyo tong cellphone ko. Yoko. Imagine nyo. Unilateral na nga yung promise, unaccepted pa. So, yan ang tawag dyan is policitation. Effect? No effect. No legal bond, offer, and it is not even accepted. So, obligation of the offeror in a valid option contract, meaning the option contract is paid with option money. So, offeror should not offer to a third party yung object during the option period. Kasi nga, nagbigay ka ng period eh. Tapusin mo yung period. Not to withdraw the offer during the option period dahil nabayaran. To hold subject matter for sale and to transfer it to the offeree in the event that offeree exercises yung option to buy during the option period. So, risk of loss in 1480. Loss before perfection, seller and not the one who intends to purchase it bears the risk of loss. Again, res perit domino, owner bears the risk of loss. We already studied this sa obligations and contracts. Here, class, there is no contract, there being no cost or consideration. So, what else? No object pa. Yan. So, payment of the price cannot be demanded. What else? Thing is lost at the time of perfection of the contract. The contract is void or inexistent. So, at the time of perfection, pero bigla nawala yung object. So, nung time na na-perfect yung contract, walang object na naman. So, again, lack of an essential element, contract is void. And obviously, in number 2, it is also the seller who will bear the risk of loss as in number 1. In number 3, this is an exception to the res perit domino rule. Thing is lost after perfection but before delivery. So, pagka before delivery, remember, the buyer is not yet the owner because delivery transfers ownership. So, wala pang delivery but after perfection, risk of loss is shifted to the buyer as an exception to the res perit domino rule. So, you have to see the implication of this exception to the res perit domino rule. So, object hindi pa na-deliver but there is already perfection of the contract and it is lost by a fortuitous event. Obviously, fortuitous event ang pinag-uusapan natin dito because if it is lost through the fault of the seller, ibang usapan dyan, seller is liable. But here, liable for damages. But here, remember, ang implication ng rule is that the buyer, dahil nga nag-shift yung risk of loss sa kanya, kahit na nawala na yung object by a fortuitous event, remember, buyer still has to pay the price. So, let us say, kotse, perfected contract, buyer does not pay yet, but remember, the contract is perfected. So, anyway, seller does not deliver yet. So, remember here, class, perfection, but before delivery, a car is lost by a fortuitous event, risk of loss is given to the buyer. So, ngayon, buyer has to pay the price even if nawala yung object by a fortuitous event. Bakit daw ganyan ang rule? Because if it is an improvement, remember, buyer also gets the improvement. But obviously, there are exceptions to this rule. The exceptions, number 1, if the object consists in fungible sold for a price fixed according to weight, number, or measure. So, if there has been no delivery yet, seller bears the risk of loss unless the buyer is in mora accipienti. Remember, the buyer here is with respect to the delivery, the buyer is the creditor. So if the buyer is in mora accipienti, seller will not bear the risk of loss. Number 2, if the seller is guilty of fraud, negligence, default, or violation of contractual term. So remember, again, grounds for liability: fraud, fraud, dolo, negligence, culpa, default, mora, and violation of the contractual term, or in other books they call it violatio. So what else? Except if also the object is generic, genus nunquam perit. What else? Ano pa ba? If the thing is lost after delivery, obviously it is the buyer who will bear the risk of loss following the principal general rule res perit domino. 1481 talks about bulk of goods. So, yung bulk of goods is, it's not used to designate a greater portion of the goods. Rather, it is used to denote yung goods as distinguished from the sample. So, ito yung sample, tapos ito yung sample ng mga goods, tapos yung pinagkuhanan ng sample is yung bulk ng goods. So, yun ang ibig sabihin ng term na bulk. So, in other words, bulk of goods means goods, it's goods talaga is the same as goods as a whole body. Yan. So, whole body. Yan ang ibig sabihin ng bulk. So, anyway, sale of goods. I think the definition of bulk is in your book. I'm not sure. Pero you can check it sa inyong book. Ano bang provision to? 1481. So, hindi pala siya naka... Oh, yun. Actually, it's defined in your book. So, anyway, sale by description. Seller sells thing as being of a certain kind. The buyer merely relying on the seller's representation or description. So, usually, buyer hindi pa niya nakita yung bulk ng goods. Ang inaano lang dito is dinescribe lang. Ito ang binebenta ko, ganitong itsura niya, ganitong kulay niya, ganitong size niya, etc. etc. So, anyway, yung bulk ng goods should correspond to the description of the seller. Now, what if, ma'am/sir, the bulk does not correspond with the description? The contract may be rescinded. So, if the thing delivered is as described, the buyer should pay for the price. Paano, ma'am/sir, kung hindi naman magamit yung thing kasi mali pala? Remember, class, that the buyer still has to pay. Kasi, basta nag-correspond, ano yung description? Yun din yung dineliver. Kung hindi mo magamit for the purpose that you bought it for, remember, hindi na kasalanan ng seller yon. Buyer still has to pay yung purchase price agreed upon. So, sale by description, describe lang tayo. Ito siya, ganito siya, maganda siya, ganitong amoy niya, etc. etc. So, yung namang sale by sample naman is wherein you present a sample. So remember here the bulk, yung whole of the goods, not major part of the goods, but yung buong goods corresponds with the sample. So, ang papakita rito, kung sa number 1, dinescribe, dito, pinakita ang sample. So, sample, the bulk of the goods must correspond with the sample exhibited. So, sample lang ang binibigay, bulk is not presented, there is no opportunity to examine or inspect yung bulk. So, whether a sale is a sale by sample determined by the intention of the parties as shown by the circumstances surrounding the transaction. Hindi naman porke nagpakita ka ng sample, matic na sale by sample na siya. Dapat yung sample is the sole basis or inducement of the sale to make it a sale by sample. Now, a sale by description and by sample is made by both by sample and by description. So, i-describe and at the same time, a sample is presented. So, here, the goods must satisfy yung warranties appropriate to both kinds of sale. So, dapat yung bulk ng goods magko-correspond doon sa description and also must correspond with the sample exhibited. So, kailangan kung ano yung pagkaka-describe, yun din ang yun din ang itsura ng bulk ng goods, and also kung ano yung itsura ng sample, yun din ang itsura ng bulk of goods. So, in 1481, remember, technically, the remedy should be annulment, not rescission. So, yun ang tandaan natin dyan. So, probably on the ground of mistake. So, substantial mistake. So, yun ang or fraud siguro. Pwede rin na fraud dyan if there is fraud. Anyway, remember here na nagkamali ang law sa term na ginamit nila. It should have been annulment, not rescission. So, what else? 1482 talks about earnest money or yung down payment known as aras, which we have already studied, given in earnest to bind the bargain. So, it signifies the perfection of a contract of sale, part of the purchase price. Yung earnest money must be deducted from the total price. So, balance lang ang babayaran, proof of perfection of the contract, as I have said a while ago. So, remember class also that yung it may happen that the option money may also become earnest money if the parties agree to the same. 1483 talks about form of a contract of sale. So, nandun na tayo, natapos na tayo sa nature. We already compared it with other contracts. Now, form, general rule, being a consensual contract, it may be entered into in any form, provided all essential requisites are present, maybe writing, partly in writing, partly oral. It may also be oral. It may even be inferred from conduct. So, perfected by mere consent. But obviously, there are qualifications. Form is required for enforceability, meaning the contract of sale cannot be enforced if it does not comply with the writing or memorandum provided by the statute of fraud. So, again, 1403 statute of fraud requires agreement to be certain agreements enumerated dun sa statute to be in some kind of writing, note, or memorandum pinirmahan ng mga parties or the agent. Otherwise, the contract cannot be enforced by action. So, I have discussed the statute of fraud extensively in Chapter 8 of Contracts. If you do not understand it, go back to the previous lectures. Contracts covered under the statute of fraud: sale of personal property at a price not less than 500 pesos. Diniscuss ko na ito kanina in passing. Sale of real property regardless of the price. Kailangan isinusulat yan. Or else unenforceable. Sale of property not to be performed within a year. So, dapat kung lagpas na ng 1 year, it should be in writing. So, applicability of the statute of frauds and perjuries obviously applies only to executory contracts, meaning no delivery, no payment yet. Now, contracts which are totally or partially fulfilled are taken out of the coverage of the statute of fraud. Yan. So, what else? Form is required for validity. Ano bang mga example na to? Form is required so that the contract of sale will be valid. So, yung una, for to be enforceable, it has to be in writing. Ito, to be valid, it has to be in writing. So, example of this one is number 2, 3 is in case of sale of large cattle, which is covered by Article 1581 in relation to Section 529 of the Revised Administrative Code. Remember, sale of large cattle must be in writing and registered with the municipal treasurer, who will issue a certificate of transfer. Otherwise, the sale is void. Form is also required for convenience of the parties. This is in relation to 1357. Form is required para ma-register siya yung sale. Like for example, in the registry of deeds in case of land, in case naman of vehicles in the LTO, ganyan. So anyway, here in 1357, remember, para convenient sa parties, they are required to execute a certain form so that the sale may be registrable. But in 1357, remember, the parties can compel one another to execute that form. What else? The rules in case of installment sales. So, 1484 actually, di naman rule sa installment sale. Ang binigay dito is rule in remedies in case of payment, failure to pay sa mga installment. So, remember here that the contract must be a contract of sale. What is sold in 1484 is personal property, and sale is on the installment plan. So, ano bang ibig sabihin ng sale? Monthly may binabayaran ka, ganyan. An installment is any portion of the purchase price to be paid at a periodic time, including down payment is also considered as an installment. So, kung hindi naman installment, a sale can also be in cash or straight payment, straight terms tawag nila. So, kung nakakita kayo ng mga sale na may babayaran ka down payment ngayon tapos babayaran mo after 1 month, hindi installment sale yon. That is considered as cash sale pa rin ang tawag dyan. So, the article here will not apply. So, remedies in case of remedies available to the seller in case hindi nakakabayad ng installment ang buyer. Number 1, elect fulfillment upon the vendee's failure to pay. Number 2, cancel the sale. We will discuss more later on. Seller can also cancel the sale if the buyer fails to pay 2 or more installments. And number 3, if there is a chattel mortgage, kasi nga personal property so hindi real mortgage. Ang chattel mortgage, ang object niya is personal property. Kotse, cellphone, etc. etc. Yun ang truck, ganyan. Yun ang mga object ng chattel mortgage. So, ma'am/sir, ano pinagkaiba ng chattel mortgage? For starters, chattel mortgage at saka pledge. For starters, since sa pledge, the creditor must be in possession of the object pledge. So, pagka nagsangla kayo sa pawn shop, ibibigay nyo yung object. Sa chattel mortgage, pwede mong gamitin yung object habang nakasangla ito sa creditor. So that is basically mainly the difference, but obviously subject to other differences which we will discuss when we go to the final portion of our course. So anyway, in case of chattel mortgage, merong nakasanglang property to secure, nakasanglang personal property to secure payment of the debt. The seller can foreclose the chattel mortgage if the vendee shall have failed to pay 2 or more installments. This is known as the Installment Sales Law or Recto Law, Act 4122, December 9, 1939. Bagong-bago, no? What you have to remember about the remedies is that they are alternative. They are not cumulative. The remedies cannot also be pursued simultaneously. So, mamili ka lang ng isa to the exclusion of the other remedies. So, you can choose to elect fulfillment upon the buyer's failure to pay any installment, kahit ilan pa. So, obviously, this is without reference to the number of installments unpaid. basta hindi siya nakabayad kahit isa lang, you can exact fulfillment of the installment na na-miss niya. Now, remember class na pwede mong kunin yung buong amount if there is an acceleration clause doon sa installment sale. Now, an acceleration clause will make the entire amount due and demandable upon default in one installment. So, isa lang ang na-default, pero dahil may acceleration clause, yung entire amount na yung due and demandable. So, in that case, pwede mong i-demand yung buong amount. But usually, for number 1, if you elect fulfillment, you are confined to the installment that has not been, that remains unpaid. So, also, number 2, if you choose to cancel the sale, obviously, you cannot elect fulfillment of the sale. So, remember here, class, sa remedy ng cancellation or rescission, mayroong mutual return doon sa buyer, yung sums received minus reasonable rent. Pero pwede rin naman magkaroon ng forfeiture clause provided it is not unconscionable. Now, number 3, if you choose, sa number 2 pala, you need at least 2 or more installments that are unpaid. In number 3, same, 2 or more installments are unpaid, and the seller can foreclose the chattel mortgage on the thing that was sold if one has been constituted, in case nga there is failure to pay 2 or more installments. So, in addition to that, remember, right to recover unpaid balance of the purchase price. So, in case of remedy of specific performance or exacting fulfillment of the obligation, siyempre magdidemanda si seller, tapos matatalo si buyer dahil nga hindi nakabayad. Tapos, the buyer will be liable to pay yung purchase price. So, yun ang balance doon sa purchase price. So, seller may still recover unpaid balance of the price on the real and personal properties of the purchaser, not exempt by law from attachment or execution. So, obviously, class, pagka meron ng judgment ang court na magbabayad ang buyer, tapos walang maibayad ang buyer, pwedeng magkaroon ng execution and attachment. Nasa book nyo yung definitions niyan doon sa mga properties ng buyer para mapambayad dun sa kanyang balance. Number 2 naman, remedy of cancellation. Failure to pay again 2 or more installments. The latter can demand, buyer can demand return of payments already made unless there is a forfeiture stipulation. Now, there must be mutual restitution, sabi ko nga kanina, pero pwede namang magkaroon ng forfeiture if the stipulation is not unconscionable. Now, foreclosure, third remedy, if there is a chattel mortgage constituted to secure yung payment ng obligation. Remember, pwedeng i-foreclose nga yung chattel mortgage na yan, and hindi na kailangan magbalik noong mga installment payment. Pero kung merong deficiency, remember, the seller cannot also recover unpaid balance of the price remaining after the foreclosure sale. Any agreement to the contrary is void. So, lease of personal property with option to buy, so is also considered as sale of personal property payable in installments. Rules in 1484 will apply as well. So, usually itong installment sales, kotse yan. So, magbibili ka ng kotse, ikaw ang buyer, tapos babayaran mo installment 5 years, tapos certain amount per month. Usually, kung mababa ang mababa ang down payment mo, 30,000 per month ang magiging installment mo yan. Kung hindi mo mabayaran, remember, the seller may have the option to exact fulfillment. Sisingilin ka niya. So, ngayon, pagka siningil ka niya, edi ayaw mong magbayad, di ka makabayad, magdedemanda sa court yan. Pagka nagdemanda sa court yan, remember, class, na mananalo sila. Siyempre, hindi ka nga nakabayad. Tapos, yung balance ng price mo, or if you refuse to pay yung obligation mo, hindi ka talaga makapagbayad, ito ang workaround dyan. Yung seller can foreclose property na belonging to the buyer. So, makukuha pa rin ng seller yung balance noong kanyang purchase price. So, anyway, in case naman of number 2, the seller can also ask to rescind yung contract. So, kailangan niyang magbalik ng mga payments made unless merong forfeiture stipulation, provided the forfeiture stipulation is not unconscionable. Imagine nyo, halos lahat nabayaran na, tapos bigla isa lang ang dinabayaran na installment, yung final installment pa, tapos wala kang ibabalik. So that is, remember, unconscionable. What else? Number 3 also, in case of foreclosure, pwede mong i-foreclose yung object na binenta sa'yo. Ay, binenta mo. So if you are the seller, tapos a chattel mortgage is constituted on the car that you sell to the buyer. Remember that if the buyer fails to pay 2 or more installments, pwede mong irimata yung kotse na ibinenta mo sa buyer based on the chattel mortgage constituted. Now, also, yung seller will sell the car will be sold in public auction, tapos lahat ng proceeds noon mapupunta sa seller. But remember, kung kulang, magkano lang naibenta yung kotse, let us say the car is worth 500,000, hindi nakabayad ng mga installments yung buyer, tapos bigla niremata ng seller yung kotse, naibenta lang niya. Let us say, ang nabayaran lang total ng buyer is 100,000, tapos 500,000 yun, di ba? So, binenta sa public auction, nabenta lang ng 200,000. So, 300,000 lamang yung total amount na nakolekta ng seller. Remember, the seller cannot anymore get yung balance ng purchase price according to the Recto law. Yun ang tatandaan natin. Now, what if, ma'am/sir, there is dalawa yung sinangla na object? Let us say, a car, which is the subject of the contract of sale, and also sale by installment, and also another car which is not covered by the contract of sale. Dati na niyang sasakyan. Remember, class, that if ang finorclose is yung kotse, which is the subject matter of the sale, there can be no recovery of the balance. Pero pagka ang finorclose is yung kotse na hindi subject matter ng sale, or car number 2, yung talagang pagmamay-ari na ni buyer, remember that the balance can still be recovered. So, yun ang tandaan natin sa 1484. Stipulation authorizing forfeiture or installments of rents paid. Pwede naman yan. Valid insofar as the same may not be unconscionable under the circumstances. Otherwise, court may order the return of the portion of the total amount paid in installments or rent. Now, that is the law with respect to personal property. How about real property? We will apply the Realty Installment Buyer Act or the Maceda Law, Republic Act 6552, September 14, 1972. Siyempre, bagong-bago na naman yung ating law. So, remember, the objective of the Maceda Law is to protect buyers of real estate on installment payments against onerous and oppressive conditions, because it can happen na wala na nga yung property nila, tapos wala na forfeit pa lahat ng pera nila, tapos mayroon pa silang utang. So napaka-oppressive kasi ng mga real estate sales, kaya ginawa itong law na to. So this is applicable on the sale or financing of real estate on installment na naman, payments including residential condominium apartments. So, whether the contract is one of sale or a contract to sell, the Maceda law will apply. So, application of the law is mandatory. Stipulation of the parties to the contrary are null and void. Talagang kailangang i-apply ito. So, pagka bumili kayo ng bahay sa Camellia, sa Fiesta, etc., etc., you have to apply the Maceda law. So, transactions which are not covered, sale of industrial lots, residential lang kasi, commercial buildings, urban land, and agricultural land, hindi covered ng installment, hindi covered ng Maceda law yan. And also, sale of land payable in straight terms. Ang sinabi ko lang na covered ay installment. Yan. So, anyway, rules, rights of the buyer and seller. In case the buyer has paid at least 2 years of installment. Yan. 2 taon na siyang nagbabayad at least. Remember, the rights of the buyer. Buyer will be entitled to a grace period within which to pay yung kanyang unpaid installments without additional interest. So, grace period is 1 month for every 1 year of installments paid. Kailangan buo yung year. Kung may sobra, hindi mo pwedeng bilangin yon as 1 year. Na hindi mo na pwedeng dagdagan yung month. This right can only be exercised by buyer once every 5 years of the life of the contract and the extensions if any. So, once every 5 years mo lamang siya pwedeng exercise yung grace period, etc. etc. Buyer is entitled to a cash surrender value. Ano yung cash surrender value? Ibabalik yung kanyang mga installment payment in case the seller wants to rescind the sale. Cancel na ng seller, ayoko nang ibenta sa buyer na yan, ang hirap magbayad. So, remember here, class, that kailangan magbalik ng seller ng cash surrender value or else he cannot cancel or rescind the sale. So, the cash surrender value is equivalent to 50% of total payments made, including down payment, earnest money, even option money is included doon sa total payments. Remember, now, after 5 years of paying installments, additional cash surrender value equivalent to 5% every year but not to exceed 90% of the total payments made. So, kung nagbayad kayo ng 5 years and below, cash surrender value is 50% ng total na binayad ninyo. If nagbayad kayo 6 years, 55%, 7 years, 60%, 8 years, 65%, 9 years, 70%. Common sense na to, 10, 75, 11, 80, 12, 85, 13 years ka nang nagbabayad, nag-default ka, ika-cancel ng seller ang sale, 90% cash surrender value, but it will not exceed 90%. So, rights of the seller. Seller obviously has the right to cancel the contract after the grace period. Requisites for validity of cancellation. There must be a notice of cancellation or demand for rescission by notarial act. So, kailangan magbigay ka ng notice of cancellation or demand for rescission of contract by notarial act. What else? Full payment of the cash surrender value. Until and unless you pay yung cash surrender value, the sale cannot be rescinded. So, this is mandatory requirement to make yung cancellation valid and effective. So, there is no actual cancellation if the buyer is not paid yung cash surrender value. So, actual cancellation takes place 30 days from receipt of the buyer of the notice of cancellation or demand for rescission of contract by notarial act. So, 30 days from receipt. Natanggap niya ngayon, bilang ng 30 days, dun pa lamang canceled yung contract. So, anyway, what if the buyer has paid less than 2 years of installment? Ang right lang niya is to a grace period. The grace period is not less than 60 days from the date the installments became due. So, within the grace period, buyer may assign yung right niya. So, pwede niyang ibigay sa iba para sila na ang magtuloy ng kanyang mga amortization. I-update lang nila yung kanyang account. So, 60 days from the date the installments become due. Right of seller, syempre, after grace period, seller may cancel the sale. After 30 days from receipt of the buyer of notice of cancellation or demand for rescission by notarial act. Grabe, napaka-wordy ng mga terms ng law. Obviously, in letter B, if there is 2 years, less than 2 years of installment paid. So, less than 2 years, remember class, there is no cash surrender value. So, kung di ka pa nakakapagbayad ng 24 months, remember, ala kang cash surrender value. So, everything is forfeited. 23rd month pababa, forfeited lahat yan kung hanggang doon ka lang nagbayad. So, anyway, additional rights of buyer. Buyer can sell his rights by a notarial act. So, iba na ang magtutuloy ng amortizations niya. Buyer may also assign his right by notarial act during the grace period. So, pwedeng ibenta, pwedeng i-assign. What else? Reinstate the contract by updating the account, bayad siya, and pay in advance any installment or full unpaid balance anytime without interest. Tapusin na niya para wala ng problema, bayaran na lahat. And ask for annotation of the full payment of the purchase price in the title of the property. So anyway, examples for yung computation ng cash surrender value. So let us say, class, there is a parcel of land with a house worth 660,000 pesos. So yun ang house and lot na binibenta. So let us say yung buyer is required to pay a down payment of 12,000 pesos. So ito yung purchase price. Tapos yung 12,000 is yung down payment. So remember here, class, that yung transaction na to, meron tayong balance na 648,000 pesos. So this is the balance. So let us say, class, the balance is payable in 15 years. Yan. So 15 years or 180 months. Tapos, so kung i-compute nyo yan, this is equivalent to 3,600 per month. Yan. Yung installment. So anyway, itong si ating buyer pays 12 months. Yan. So, buyer pays 12 months. Okay yan. Good siya dyan sa 12 months. However, after 12 months, yung sa 13th month and the succeeding months, nag-default na siya. So, hindi na nagbayad yung buyer. So, remember, class, here, because payment is, installments paid is less than 2 years, remember, class, na walang cash surrender value. But the buyer will be given a grace period of GP, remember, not less than 60 days. Yun ang sabi ng law. So the buyer has not less than 60 days to update yung kanyang account. Now what if, class, try natin buburahin ko. Huwag na natin, ako na lang mag-isa. So anyway, same problem. 648 ang balance. Again, payable in 180 months or, as I've said a while ago, 15 years. So anyway, let us say, class, seller ay buyer pala. Buyer pays 50 months. Yan. 50 months paid. Yan. But after that, the buyer defaulted on the 51st month. So, meron ng default ito. Default. Tapos, remember, class, payment is 2 years and more. So, meron siyang, obviously, grace period. How long is the grace period? So, 50 divided by 12, around 4 years. So, there is 4 months of installment, 4 months grace period ang ibibigay. Now, also, remember that if doon sa grace period na 4 months, hindi nabayaran ng buyer yung kanyang account, hindi niya na-update, remember, class, na yung seller may choose to cancel the sale if the buyer does not pay within the grace period. So, magpapadala siya ng notarial cancellation by notarial act, demand for rescission by notarial act, or notice of cancellation. Magpapadala siya ng ganon. So, after 30 days, mare-rescind yung sale. But of course, the seller has to return yung cash surrender value. Now, the question is, magkano ba yung cash surrender value. So, tingnan muna natin magkano kasing binayad niya. So, ang binayad niya is, let us say, 50 months times 3,000. Remember, yung installment natin is 3,600 per month as we have computed a while ago. Ay, ako lang palang nag-compute. Pero anyway, basta. So, remember, installment payments is equivalent to 180,000 pesos. Lahat-lahat. Ito yung mga installments. Tapos, plus 10,000 pesos. Ito, ano yung 10,000, ma'am/sir? Down payment. Ay, 12 pala yun, down payment. 12. Ano ba yung burhen? 12. So, anyway, ano ba yan? 12. Yan. So, 180,000 installments. Tapos, yung down payment is equivalent to 192,000 pesos. So, 192,000 pesos, that is the total paid. Yan. So, remember class, dun sa total paid, kailangan ang cash surrender value is equivalent to 50% of the amount totally paid. So, times, remember, 50%, and the equivalent, the sum here is, remember, the product here is 96,000 pesos. So, this will be your cash surrender value. So, 50%. Now, what if, class? This is the problem. Ito, buburahin ko na uli. Anda rito. Yan. Ay, ayaw mabura. Matigas ang ulo. Yan. Oh, anyway, yan. What if, class, 100 months na ang nabayaran? Wow, 100 months. Remember, ang ating installment is 180 lang. 100 months na ang nabayaran niya. Pero dun sa pang 101 ay nagkaroon na ng default. Onwards, di na nabayaran yung installment. So, yun. So, anyway, remember class here na meron syempreng grace period. So, grace period is equivalent to 1 month per year of installment. So, 100 months times 100 months divided by 12 equal to 8.3. So, 8 months. 8 years ng payment, 8 months ng grace period. Now, again, kung hindi nakapagbayad sa grace period ang buyer, the seller may choose to cancel the sale by sending a notice of cancellation or demand for rescission by notarial act, and also paying yung cash surrender value. The actual rescission will happen 30 days after receipt of the notice of cancellation, etc. But obviously, kailangan ding bayaran yung cash surrender value. Kung walang cash surrender value, hindi valid and effective yung cancellation. So anyway, magkano ang cash surrender value? So, remember, 100 months at 3,600 installment per month. So, 360,000 yung total number of installments paid. What else? Idagdag natin yung 12,000 na, again, down payment. So, down payment. So, 360,000 plus 12,000 na down payment. 300. Akala nyo ba kayo lang marunong gumamit ng calculator? Ako din. So, anyway, 372,000 yan ang total amount paid. So, total. Now, question, magkano ang cash surrender value? Remember, 5 years. Kung 5 years and below, 50%. Yan. Pero pagka nadadagdagan ng year, 6th year, dadagdagan mo ng 5%. 7th year, dadagdagan mo na naman ng 5%. 8th year, dadagdagan mo na naman ng 5%. So, remember here, kailangan siya ay dito na lang, 65%. Kasi 50% sa 5th year, 60% sa 55% sa 6th year, Sa 7th year, 60%, and sa 8th year, 65%. So, times 65%, times 65% equals 241,800. So, this will be your cash surrender value. So, let's proceed to the subdivision and Condominium Buyers Protective Decree or PD Presidential Decree number 957 July 12, 1976. So please take note of the transactions covered. Sa law din dinefine yung subdivision lot and also yung condominium unit. I-check nyo na lang. Anyway, the usual definition will suffice. Transactions covered by the sale or sell, contract to sell of condominium unit or a subdivision unit, every disposition or attempt to dispose for valuable consideration of a subdivision lot, including the building or other improvements thereon. So, kung may nakatayo doon, kasama, if any, in a subdivision project or condominium unit in a condominium project. So, what else? Contract to sell, contract of purchase and sell, exchange, attempt to sell, option of sale or purchase, a solicitation of sale, or an offer to sell directly or by an agent or by circular letter, advertisement, or otherwise are also covered transactions dun sa Subdivision and Condominium Buyers Protective Act. Now, remember, rights of the buyer in case of default. In case of failure to pay installments other than failure of the owner or developer to develop the project shall be governed by the Maceda law. So, in short, the Maceda law applies in case of subdivisions and condominiums on sale by installments. So, mag-a-apply din yung Maceda law. Now, in case naman of failure of the owner of the subdivision or condominium unit to develop the subdivision or condominium project according to the approved plans and within the time limit for complying with the same, pwedeng i-cancel ng buyer yung sale with after due notice to the owner of or developer. Tapos, syempre, hindi na siya magbabayad ng he will be excused from making further payment and also yung mga installment payments already made ay hindi mafo-forfeit in favor of the seller. So, the buyer may be reimbursed the total amount paid, including amortization interest, but excluding the delinquency interest, with interest thereon at the legal rate. So, please take note of the miscellaneous provisions 1487. Vendor has the duty to pay not only the expenses for execution of the sale, but also for registration. So, by law, remember class that it is the seller who has to pay for the expenses of a sale, including the registration of sale. So, yun ang rule. Unless there is a stipulation to the contrary. So, tignan nyo muna, ano muna ang stipulation. If there is no stipulation, it is the seller who will pay for the expenses. So, kung kayong seller, mautak kayo, stipulate regarding payment of registration and also execution of the sale. What else? Expropriation of property for private use covered by 1488. So, procedure for the exercise of this power of eminent domain is provided for in Rule 67 of the Rules of Court. So, expropriation is the process. So, yung power of eminent domain is the power of the government to get private property for public use upon payment of just compensation. Bayad siya ng just compensation, tapos pwede niyang kunin yung private property for public use. So, expropriation is the process. Yan yung case na fina-file mo or yung process that is undergone in order to yung acquire yung private property. So, expropriation is always decreed by competent authority for public use and always upon payment of just compensation. So, pagka na-filean kayo ng expropriation case, the first phase of expropriation case is to determine whether or not the use is, the taking of the property is proper. Public use ba talaga yan? Wala na bang ibang option? Kung public use, tapos wala nang ibang option na property, syempre, taking is proper. Yan. So, if they determine that taking is proper, the second part of an expropriation case is the determination of just compensation. So, magkano ba dapat ang ibayad dito sa lupa na kinuha ng gobyerno? So, expropriation is the process. Eminent domain is the power or right given to the state. So, anyway, just compensation, market value, price which the property will bring if it is offered for sale by one who wants to sell but it is not obliged to sell, and binili ng isang buyer na gustong bumili pero hindi naman kailangang bumili, plus consequential damages if any, minus consequential benefits if any. So yun ang tandaan natin sa expropriation. Essential requisites, idagdag natin. Taking is by competent authority, observance of due process, meaning go to court, give the property owner the right to be heard. Yan. Taking for public use and also payment of just compensation. So anyway, that's it for chapter 1, very long chapter. I hope you will have the patience to watch the entire lecture. Thank you and good night, class.